This is part one of a three-part series. Today, part one will be dealing with understanding the privacy aspect of HIPAA compliance. Now, I do ask that you pay attention today, for you're actually going to be tested later on the materials that are presented. And this training seminar program today is intended to provide you with a basic and general understanding of the HIPAA privacy rule. You see, this program is not intended to be an all-encompassing and completely inclusive course on the HIPAA privacy rule. You should actually regularly review your practice's HIPAA policies and procedures for further comprehension and knowledge of HIPAA. And any questions that you have regarding HIPAA, the privacy rule, and or any other portions of HIPAA for that matter, should immediately be brought to the attention of your practice's HIPAA privacy officer. This is also not legal advice, and what I mean by that is the information provided today is strictly for educational purposes only, and is not, nor is it intended to be, considered or interpreted in any manner whatsoever as legal advice. Additionally, this is not a one-and-done type of compliance program. You see, simply by listening to this video or attending a seminar or watching this video in no manner whatsoever provides a guarantee of compliance with HIPAA. At a minimum, continuous compliance with HIPAA requires an ongoing and active implementation of your practice's HIPAA policies and procedures, as well as current updates, reviews, and maintenance of your policies and procedures, the regular training and testing of your workforce members, the testing of your implemented security and privacy standards, and performing an annual risk analysis. So therefore, what I mean is, more work still actually needs to be done. Although informative and educational, this training seminar is not intended to replace or substitute the necessity for ongoing internal HIPAA training and testing of your workforce members, as well as the regular review and updates as needed and necessary of your HIPAA policies and procedures. The continued maintenance of your compliance program is mandatory, and this training seminar is just one aspect of your overall HIPAA compliance program. Now, SMB Networks provides HIPAA compliance program materials and training seminars to your practice, but no representative of SMB Networks is acting as the privacy compliance officer or any other type of compliance officer for that matter for your practice. It's therefore incumbent upon your practice, as well as mandated by HIPAA, to designate a HIPAA privacy officer. Your practice's HIPAA privacy officer must familiarize him or herself with HIPAA and all of the required rules and regulations. And there's certainly more than meets the eye today. Now, every effort has been made to facilitate an effective and well-designed HIPAA compliance training seminar program. However, in the interest of time efficiency, some topics will be abbreviated and others, well, they won't be discussed at all. Additionally, there may be some exceptions in the HIPAA rules to the topics addressed today. Therefore, I encourage you, any and all questions that you have regarding HIPAA should immediately be brought to the attention of your practice's HIPAA privacy officer. Now, before we get started, you might have some questions, and the first of which is probably, why am I even at this HIPAA training seminar? Well, the answer to that is because you're a member of this practice's workforce. And according to HIPAA, a workforce member means an employee, a volunteer, a trainee, and any other persons whose conduct and the performance of work for a covered entity or business associate is under the direct control of such covered entity or business associate, regardless of whether or not they are paid by the covered entity or the business associate. And you must attend this HIPAA training seminar program because HIPAA applies to your employer, and HIPAA actually requires your employer to provide HIPAA training. But most importantly, what I want you to understand is that as a member of this practice's workforce, HIPAA applies directly to you. Now, regardless of the size of your practice, you must comply with HIPAA. There are certainly no exceptions nor exclusions for the size of a covered entity or a business associate. There are some important abbreviations I want you to be aware of. CE stands for covered entity, and BA stands for business associate. BAA stands for business associate agreement. EPHI stands for Electronic Protected Health Information. IIHI is Individually Identifiable Health Information. PHI stands for Protected Health Information. HIPAA is the acronym for the Health Insurance Portability and Accountability Act, which was passed by Congress back in 1996. It applies to both covered entities and business associates. It requires the protection and confidential handling of protected health information to protect the security and privacy of such information. It also requires covered entities and business associates to develop, implement, and enforce policies and procedures for the protection of an individual's protected health information. Now, in regards to the three-part training seminar series, I want you to be aware that there are basically three elements for you to be aware of in HIPAA: privacy, security, and enforcement. Now, this is part one of the three-part series, so HIPAA privacy is going to be the focus of our training seminar today. PHI, or Protected Health Information, means individually identifiable health information that is transmitted by electronic media, maintained in electronic media, or transmitted or maintained in any other form or medium. Well, if we think of transmitted by electronic media or maintained in electronic media, we're talking about electronic protected health information that is stored on a hard drive of a computer or device or anything of that sort that is electronic, that you can retrieve, see on a computer screen or a monitor. When we talk about transmitted or maintained in any other form or medium, we're talking about a paper trail, if you will. Think about records in an actual file that you can pick up and look at and flip through. Now, protected health information excludes individually identifiable health information in some education records, in employment records held by a covered entity in its role as an employer, and also regarding a person who has been deceased for more than 50 years. Individually identifiable health information, or IIHI, is information that is a subset of health information, including demographic information collected from an individual, and it is created or received by a healthcare provider, such as a practice, a medical practice that you might be working for right now, a health plan employer, or a health care clearinghouse, and it relates to the past, present, or future physical or mental health or condition of an individual, or the provision of health care to an individual, or the past, present, or future payment for the provision of health care to an individual, and it identifies the individual, or with respect to where there's a reasonable basis to believe the information can be used to identify the individual. So let's look at some examples real quickly of protected health information. These can be both electronic and or in paper form. Think about encounter or visit documentation that might be stored on a computer or in the alternative physically in somebody's file. Lab results, appointment dates and times, invoices, radiology films and reports. Also, what about some history of physicals and anything else you can think of? Protected health information also includes patient identifiers, and think of patient identifiers as information by which the identity of a patient can be determined with reasonable accuracy and speed, either directly or by reference to other publicly available information. So think about it. You open up a file and you see who the person is. You can directly identify them, make it out, everything, their name, their address, their social security number, you name it, everything is in there. But what if you didn't have all the pieces to the puzzle? What if you only had a couple pieces in a file, let's say? But just from those pieces of that puzzle, you can go on any other publicly available information, such as the internet, a website, anything else. Now, you can take that piece of the puzzle that you took from the file, but you don't know who that person is. But if you start matching it up with other stuff that you can find publicly, again, think of the internet, very powerful tool. Now you connect the pieces of the puzzle. Now, by taking the one piece that you had and the other piece that you just found on the internet, let's say, for example, you piece those two together. Now you can make out who the identity of this individual is. So some examples of protected health information patient identifiers. Names. Well, obviously names are going to be there. All elements of dates and birth. All elements of dates, including birth date, death date, admission date, discharge date, etc. Postal address information. Telephone and fax numbers. An email address. Social security numbers. Medical record numbers. Health plan beneficiary numbers. Account numbers, certificate and license numbers. Here's one a lot of people don't even think about: the VIN number on your vehicle, and serial numbers, including license plate numbers, device identifiers and serial numbers, web URLs, IP address numbers, biometric identifiers, including finger and voice prints, a full face photo, and any comparable images, and any other uniquely identifying number, characteristic, or code. So let's get started with the HIPAA privacy rule. The major purpose of the HIPAA privacy rule is to define and limit the circumstances in which an individual's protected health information may be used or disclosed. Now, HIPAA is intended to protect the privacy and security of protected health information, but it's certainly not there to paralyze your practice from operating. You see, it's simply erroneous to believe that HIPAA supports a complete ban on using and disclosing protected health information. These rules, what's with all these HIPAA rules? Well, your practice must have in place appropriate administrative, technical, and physical safeguards to protect the privacy of protected health information. You see, your practice must reasonably safeguard protected health information from any intentional or unintentional use or disclosure that is in violation of the standards, implementation specifications, or other requirements of HIPAA. So now let's take a look at using and disclosing protected health information within your practice. First and foremost, here's what HIPAA has to say about using and disclosing protected health information. You may not use or disclose protected health information except as permitted or required by the HIPAA rules. So take a look and notice how the rule is first written by stating you may not use or disclose protected health information. And if that's all that it said and nothing else behind it, that would be pretty simple. You would not use or disclose protected health information. But you and I both know that a practice can't operate like that. So there's an exception. The small exception is so long as it is permitted or required by HIPAA. So again, look at that definition, or you could actually say, look about using and disclosing protected health information. You may not use or disclose PHI except as permitted or required by the HIPAA rules. So now we know the groundwork. Now we know the basis. Now we know the rule. There are required and permitted uses and disclosures of protected health information. Now, your practice is required to disclose protected health information to an individual and when requested by the Secretary of the Department of Health and Human Services. On the other hand, your practice is permitted to use and disclose protected health information to the individual, to family members of the individual, or personal representatives of the individual for treatment, payment, and healthcare operations, by authorized workforce members within your practice, pursuant to a valid authorization made by the individual who is the subject of the protected health information, by agreement of the individual or personal representative of the individual, where there is the opportunity for the individual to agree or object to the use or disclosure of the protected health information, and to business associates, so long as there is a valid business associate already in place and signed. Now you may be thinking, now wait a minute. Since my employer is permitted to use and disclose protected health information, and I'm a member of my employer's workforce, can I just use and disclose protected health information? The answer to that question is no, not necessarily. See, before you can access protected health information, you must first receive authorization by proper personnel within your practice to have access to protected health information. And usually that proper personnel is going to first start with your practice's HIPAA privacy officer. And your employment position duties and responsibilities should mandate whether or not you have access to protected health information and what level of access you have. For instance, you may have a position in this practice whereby you do not need, for any reason whatsoever, the ability to access a patient's protected health information. And if that's the case, that's fine, because those are your job duties and description, as that is your employment. Or in the alternative, you may be a volunteer or an intern. And additionally, the function of your job duties and description as an intern or a volunteer does not warrant the necessity for you to look at a patient's protected health information. If that's the case, this practice should prohibit you from ever accessing, looking at any protected health information whatsoever. But let's say, for instance, you're a workforce member here and you are permitted access or granted the permission to access protected health information. In that instance, you're not permitted to access PHI beyond the scope of your identified level of access pursuant to your employment duties and responsibilities. So therefore, While you may be able to access protected health information, you may have a certain level, such as you might be only able or permitted to access protected health information for patients who are coming here today for the purpose of seeing or being treated. If that is the case, that is all the level of protected health information access that you have, meaning you may not go and look at any other patients who are not coming in today for the purposes of treatment or whatever other necessity they are coming to the practice for. Or in the alternative, you may be able to access an individual's protected health information irregardless if they are coming in today or if they were a former patient. But yet you cannot go and look, that is, snoop for your own purposes, this patient's protected health information just because you want to see what's going on. If it's not within your job duty and description to be pulling that protected health information, plain and simply then, you shouldn't be. Because any access beyond what your employer permits is in direct violation of HIPAA. And it can actually result in employment sanctions, including your termination, as well as the monetary fines for your practice. And quite possibly, you might be incarcerated. The use and disclosure violations. Once again, even if a workforce member in your practice has permission to access protected health information as part of their regular duties and responsibilities, if that workforce member goes beyond the scope of their duties and responsibilities for permissibly accessing PHI, that is, you pull a patient's file that the workforce member had no reason to access other than to snoop, that's a violation of HIPAA. Here's another example of going beyond the permissible access of protected health information. Let's say, once again, a workforce member, maybe even including yourself, has permission to access PHI. But this workforce member regularly reviews protected health information of celebrities, athletes, reality stars, local politicians, members of the public who have been in the media. What about their spouse, partner, boyfriend, girlfriend, regardless if they are current or former, a relative, a neighbor, another workforce member in your practice who happens also to be a patient of your practice, etc. But you or that other workforce member's duties at the time of viewing the protected health information did not permit such access to the protected health information. In this example, that is a violation of HIPAA's permitted use of protected health information. Now, there are essentially three types of disclosures for protected health information. You have the intentional disclosure, you have an accidental disclosure, and you also have what are known as incidental disclosures. So let's take a look at all three disclosures right now. Intentional disclosure of protected health information. Well, intentional disclosures of PHI is exactly what it sounds like and, well, what it means. You, as a workforce member of this practice, intentionally disclose PHI to another individual or entity. And this can either be good or, in the alternative, it could be bad. See, a good intentional disclosure is permitted by HIPAA, and your practice is HIPAA's policies and procedures. A bad intentional disclosure, well, that violates HIPAA, and it also violates your practice's HIPAA policies and procedures. You will get into trouble and could be terminated. In some instances, like I said before, you could be incarcerated. Let's look at good intentional disclosures. These are all in compliance with HIPAA. An individual requests their protected health information or copy thereof. You give it to them. An individual fills out an authorization that is valid and is complete, telling you to disclose certain protected health information, or in the alternative, all of their protected health information, to another entity, let's say a law firm, for treatment, payment, or healthcare operations. Obviously, there needs to be billing to insurance companies in order for a practice to receive payment for the services rendered. How about whether your individual says, yes, I want you, pursuant to an agreement, to disclose this information to so-and-so, or to give it to so-and-so. When instructed to use and or disclose by an authorized workforce member, somebody tells you, hey, I need you to pull this file, and you go and pull it, and that person who asked you to pull it and or instructed you to pull the file has the authority to tell you to do so, and you are doing it under the guise and direction of that workforce member. That is permitted. When it is required by law, when it is permitted by HIPAA's rules and regulations. and when it is required by the Secretary of the Department of Health and Human Services. All of these, again, are examples of good intentional disclosures. Now I'm going to give you a series of bad intentional disclosures, and please do not even attempt any of these. Talking about disclosing, that is, individuals' protected health information with friends, family, spouse members, etc., whoever is a non-workforce member of this practice. Talking about, which again is disclosing individuals' protected health information with other workforce members who have no authority or permission to have knowledge of the individual's protected health information. So, you may be talking to another workforce member. You both work for this practice, but yet that person that you are speaking with, that workforce member, their job duties and description does not permit them access to that particular patient's protected health information, but yet you're giving them this information. You shouldn't be, and that is a violation of HIPAA. How about talking about individuals' protected health information with other workforce members who do have the authority to have knowledge of that particular individual's protected health information, but yet your conversation takes place in a non-confidential area, such as an elevator, cafeteria, your practice's waiting room, a patient room, etc., where others can hear the conversation. That is also a violation of HIPAA. Talking about disclosing individuals' protected health information on the telephone and others who are not permitted to access protected health information within your workforce can hear you. Texting or emailing individuals' protected health information with other workforce members who have no authority or permission to have knowledge of the individual's protected health information. Again, these are all bad. Posting individuals' protected health information on social media websites, and yes, believe it or not, this does happen. Showing other workforce members individuals' protected health information when you yourself do not have permission to access the individual's protected health information for the purposes of such disclosure. Again, you are snooping, or it's like gossip. It is not permitted. Also bad, showing, that is disclosing, others photos of patients which contain protected health information, illegally selling protected health information, threatening to blackmail or embarrass individuals with their protected health information, permitting other workforce members to use your login and password to gain access to protected health information that may be stored on a computer, let's say. Emailing, texting individuals' protected health information to unauthorized individuals. Continuing with bad examples, installing malware, spyware, viruses, allowing others to gain access to protected health information. By doing a favor, quote unquote, for somebody, by providing them a copy of their own protected health information without having them first go through the proper and standard policies and procedures and channels for acquiring a copy of their protected health information from your practice. That again is a bad intentional disclosure. Also, intentionally leaving protected health information anywhere, and by anywhere I mean in your practice and or outside of your practice, where others can view it. And any other examples you can think of whereby protected health information is intentionally disclosed for any other purpose that is in violation of HIPAA. Please, think with your head and not with your heart. What I mean is, more often than not, you're going to find yourself in a compromising position wanting to genuinely assist someone. Now that someone could be a coworker, a patient, a best friend, a neighbor, a spouse, relative, sibling, former boss, former coworker, whomever, in their greatest time of need. And as honorable as it may appear for you to help this individual at that particular moment, please remember that HIPAA is still controlling, and any type of use and or disclosure is still mandated by HIPAA and your practice's HIPAA policies and procedure. Please do not ever make the potential grave "this is the only time" error, mistake, and violate both HIPAA and your practice's policies and procedures. The consequences could be dire for both you and your practice, with one of the results including your termination. Always remember, I hate to say it, but no good deed goes unpunished. Okay, so we looked at the intentional disclosures, and we saw the good and the bad of the intentional disclosures. Let's look now at accidental disclosures for protected health information. We're all human, and accidents will occur, and human error of type of accidents will also occur on a regular and daily basis. An accidental, non-intentional disclosure of protected health information means that you accidentally provided an individual's protected health information to the wrong person. This can happen in a number of ways, one of which is sending, that is disclosing, via email, regular mail, fax, etc., protected health information to the wrong recipient. Physically handing protected health information to the wrong individual as they are leaving your practice. Leaving a voice message disclosing protected health information to the wrong individual. Accidentally leaving protected health information out in the open where others can view it. And any other example of disclosures you can think of where protected health information is accidentally disclosed. Now, I want you to understand too, the sending, the leaving of voice messages, anything like that in regards to protected health information. I'm certainly not one to advocate emailing anyone protected health information, or faxing protected health information, or leaving a voice message regarding protected health information. And I want you to understand that your practice is controlling. So if your practice's policies and procedures mandate that you regularly email on a regular basis and the email is encrypted, then that is how it is being sent. This is just a training seminar for the purposes of saying what is an accidental disclosure. Like for instance, your practice may not ever want to leave voice messages to anyone with any sort of protected health information. And quite frankly, I think it's a good practice that says, "Hi, this is so-and-so from such and such practice, please call me back," and leave it at that. Think about it. There's no protected health information on that message. Simply, if you left it for the wrong person, they may call you back and say, "What's this about?" "Well, are you so-and-so?" "No, I'm not. I think I got the, you called me by accident." "Okay, we're sorry about that. Thank you. Goodbye." And that's all. It's not protected health information that you were disclosing. Although accidental, these types of disclosures are not intentional. They could rise to the level of a reportable breach. Therefore, whenever there's an accidental disclosure, you must immediately report it to your practice's HIPAA privacy officer without exception. You see, even though your intention may be to simply fix the problem or just make it right, never, and I mean never, attempt to quietly correct or reverse what was done. Rather, simply immediately report it to your HIPAA's privacy officer. While the disclosure may be accidental, your failure to immediately report the incident to your privacy officer may be considered a deliberate, intentional attempt to cover up the incident, and actually could result in severe sanctions and/or the termination of your employment. Now finally, let's look at incidental disclosures of protected health information. The HIPAA privacy rule permits certain incidental uses and disclosures of protected health information to occur when the covered entity has in place reasonable safeguards and minimum necessary policies and procedures to protect an individual's privacy. We'll go over in a little bit the minimum necessary rule here. But what I want you to understand is that an incidental use or disclosure that occurs as a result of your practice's failure to apply reasonable safeguards or the minimum necessary standard where required, that is not permitted under the privacy rule, and that is a violation, meaning that won't be considered incidental disclosure because not enough was done to protect the incidental disclosure from rising to the level of an intentional or an accidental disclosure that could have been prevented. And let me get into a little bit more detail here. HIPAA realizes that a practice has to operate, and HIPAA realizes that not every single practice is going to have a cone of silence where you can speak to any individual and not ever be overheard or seen by anyone. And HIPAA addresses this. You see, HIPAA realizes that inadvertent protected health information disclosures made while performing your job duties during the normal course of business is acceptable. And despite your practice's best efforts, let's say a visitor or another patient overhears PHI being discussed or may glimpse at a patient's information on a sign-in sheet or patient whiteboard. So long as it was not an intentional disclosure by your practice to have this patient purposely see this information, or in the alternative, purposely overhear what was being said on the phone, it's going to be an incidental disclosure. HIPAA does not want your practice shutting down. They want you to be able to operate, but they also want you in the same breath to protect a patient's protected health information. As such, covered entities like yourself must implement reasonable safeguards to limit incidental and avoid prohibited uses and disclosures. So generally, there's not going to be any liability for the disclosure of this protected health information so long as reasonable precautions are being taken to safeguard the individual's protected health information. Once again, the purpose of HIPAA is to protect an individual's protected health information and certainly not paralyze a practice. So the normal course of business, if people are walking into a room where they're going to be seen by a physician and they're walking past an individual who may be paying for their treatment for that day, and if something is inadvertently said, but it is not said in a very loud tone, but regularly in a normal voice, or even in a lessened voice, being whispered, if you will, but yet this is overheard, generally no liability against any practice for something of that sort. No liability against the incidental use or disclosure of protected health information. But again, the reasonable safeguards have to be in place so that you're not just announcing it regardless of who's around. You know, if you look around your environment, you see who's around, you're doing your best, but yet you still have to operate. Now let's look at some examples of disclosures that are not incidental and quite frankly, possibly HIPAA violations. You're performing your job function discussing protected health information with an individual or other authorized individuals, but you are doing it intentionally. And that's important. You're doing it intentionally and directly in the presence of workforce members or other individuals. And by other individuals, I mean visitors in your practice that are not patients. They may be repair individuals, or they may be individuals who are there for any other purposes other than to see any physician. And you are making this discussion of the protected health information directly in their presence, and you know that they should not be listening to or overhearing this protected health information, and it is purposely being overheard by them. And that is the intent that you have, that you're going to announce something for, let's say, to embarrass this patient or whatever it is. That is not an incidental disclosure. That is more of an intentional disclosure. How about not making an effort to lower your voice when speaking with an individual regarding their protected health information in an open location in your practice? There may be the need and necessity for you to discuss a patient's protected health information during the normal and regular course of business. And HIPAA understands that. But HIPAA also understands that you could probably lower your voice if practical. And if you can, please lower your voice. Do not speak in a loud tone that other people can hear you. Look at also openly discussing the reason for an individual's visit in the presence of others not permitted to have knowledge of the individual's protected health information. Quite frankly, you often see this when a patient walks in to a reception area just to announce that they are there, possibly to sign in, and a discussion could ensue whereby the individual behind the counter wants to gain more information. If it's not necessarily needed at that time, or information could just be written down quietly, that is probably a better course of action to take rather than to announce, okay, what are you here for? And how is such and such going with you? Or, you may become friends with some of the patients, start talking about their case that they're there, or the reason that they're there. Please don't do that. Speaking of checking in addition to having an individual write their name on your practice's sign-in sheet, you request additional medical information that's not necessary for them to sign in. That again is not an incidental disclosure, but more of an intentional use and or disclosure that is not permitted by HIPAA. And as we discussed, leaving a voice message with an individual and disclosing protected health information on their voice message. It's probably best practice. Just call the individual and say, please call me back. I wouldn't leave any protected health information because, once again, you don't know who could overhear that voice message. How about leaving protected health information in an area where it can easily be viewed, taken, or stolen, such as you walk into a break room, you put files down. You know they're there, but you just don't want to take them back yet. You just want to go and do something else. That's an intentional disclosure because anybody can grab them. How about on your computer monitor? You're typing up stuff. You're going to walk away to take a break, or you have to just get away from your workstation for whatever reason. If that's the case, have the screen go blank. See if there's a way that the screen or the computer can be locked so that no one can access it. How about if you're typing up on your computer or monitor and it's also facing patients, or in the alternative, facing when patients walk by? Can you turn that screen around? And if you can, you should. Incidental disclosures. Your practice must reasonably safeguard protected health information to limit incidental uses or disclosures made pursuant to an otherwise permitted or required use or disclosure of the protected health information. Let's look at some safeguards now. How can you prevent an incidental disclosure from rising to another level? Well, just use common sense when disclosing protected health information. Think about it. Where are you? Who is near you? Who can hear or see you? Can you move to a more private or secure area? Speak quietly when discussing protected health information. Remember, don't leave any paper or physical protected health information where others can easily view it. Train all workforce members not to engage in open conversations with any patients or visitors regarding their protected health information. Now, if possible, again, only if possible, and if you already have an empty space or office room, what if you can designate that empty space or office room or area for discussions of protected health information so that it's outside the viewing area, or in the alternative, the listening area of others and other individuals, and it's a more private and secure and confidential location. Again, HIPAA is not looking for you to design and build anything like this, but only if you have a space in your practice now that you're not utilizing, why not use it for that purpose? Take those monitors and turn them away from public viewing, and activate screensavers on all monitors, so that once again, you walk away, screensaver comes up, it's a blank screen, or it may just be a picture. Nothing that is anything related to protected health information whatsoever. Those patient charts outside the doors of the room that the patient is in, why don't you turn them around to face the door so that the only thing that people see is either the back of the page, and by back of page I mean it might be the back of the folder, and nothing is written on there. Remember I was telling you about the minimum necessary rule? Well, let's take a look at it a little bit more greater detail here now. The minimum necessary rule. I want you to remember, for this is required by HIPAA, when you are using, disclosing, and or requesting protected health information, both you and this practice must make reasonable efforts to limit protected health information to the minimum necessary to accomplish the intended purpose of the use, disclosure, or request. So, whatever it is that you need to request, use, or disclose of protected health information, any bit more than what is actually necessary to accomplish the task at hand is a violation of HIPAA. For instance, if someone says, well, I need you to disclose or send or whatever it is that they want of a certain portion of their protected health information, it may be a variation of dates. They want something from July through September of this year. If that's the case and you send more information, you send from January and February to whomever they want you to disclose it, that's a violation of HIPAA. If you yourself start filtering through and just for purposes of snooping what happened back in January, February, or March, and those aren't the dates of service that they're asking you to send out, once again, you are violating HIPAA. Now, the minimum necessary rule does not apply to disclosures or requests by a healthcare provider for treatment, nor does it apply to uses and disclosures made to the individual as permitted under the privacy rule. And uses or disclosures made pursuant to a valid, compliant HIPAA authorization. Disclosures made to the Secretary of the Department of Health and Human Services in accordance with HIPAA. Uses or disclosures that are required by law, and or uses or disclosures that are required for compliance with applicable requirements of HIPAA. Once again, do not use, disclose, access, or even request more protected health information than what is minimally necessary to accomplish the purpose of the use, disclosure, access, or request of the protected health information at hand. Now, the minimum necessary standard also applies to your workforce in regards to, applies to your practice in regards to the workforce members. What I mean by that is the minimum necessary standard requires your practice to limit which workforce members have actual access to protected health information based on who needs access to perform their job duties. For any workforce member permitted to access protected health information, your employer must identify the category of protected health information to which the access is needed and any conditions appropriate to such access. For example, let's say a medical practice workforce member is allowed to have routine, unimpeded access to patients' medical records where such access is not necessary for the workforce member to do their job. In this instance, the practice is not applying the minimum necessary standard. Once again, Your practice should designate which workforce members need, pursuant to their job duties and description, access to protected health information. Those who do need access to protected health information should be limited to the level. So they may not be able, for some of them, they may not be able to go back and look at anybody's protected health information, perhaps only patients that are coming in today. The other alternative, some may have need to access all patients' former and current protected health information, irregardless of the date of service. And others, well, they may not need any access to protected health information whatsoever. In that instance, in order for your practice to adequately and properly utilize the minimum necessary rule, there needs to be the designation of who needs access and to what level. This practice, your employer must make reasonable efforts to limit the access of such authorized persons to protected health information. Remember, what is minimally necessary is what is reasonably necessary. Now let's switch gears a little bit here and talk about incident reporting, and this is very important. Reporting any HIPAA violations or any violations of your practice's HIPAA policies and procedures to your practice's HIPAA privacy and or security officer is mandatory. You must, and I repeat, must immediately report to your practice's HIPAA privacy officer any and all uses and disclosures, and by any and all I mean intentional, accidental, and non-incidental, of protected health information which are in violation of your practice's HIPAA policies and procedures and or the HIPAA rules in general. This includes any unauthorized use and disclosure committed by you, by any other workforce member, or any other covered entity or business associate representative your practice is involved with. And even if you did not personally see the violation committed, but simply overheard someone mentioning what they saw or heard, you must also immediately report that incident to your practice's HIPAA privacy officer. You see, as a member of your employer's workforce, you yourself are responsible directly for protecting and keeping all protected health information you have permission to access, safe and private within the confines of HIPAA. Even if you, as a workforce member, or any other workforce member for that matter, does not have permission to access protected health information, and if you should inadvertently somehow notice this protected health information out in the open, you or this particular workforce member must take the immediate and proper steps to protect the privacy of the protected health information and immediately report the incident to your practice's HIPAA privacy officer. And if you think something or someone may be jeopardizing or compromising the protected health information in your practice, once again, immediately report it to your practice's HIPAA privacy officer. A great rule of thumb: if you see or hear something which is or could be a HIPAA violation, simply immediately report it to your HIPAA's privacy officer, your practice's HIPAA privacy officer. And let's look at, again, some rules for protected health information use and disclosure. Minimum necessary is coming up again here. So do not access, view, use, disclose, request protected health information if it is not part of your job duties and or description. If you do have permission to access protected health information, share it only with other workforce members who also have permission to have access to that particular protected health information, and require that the protected health information is needed to properly perform their job function. Never leave your workstation with protected health information visible on a computer screen, nor leave an individual's files or records unattended. Do not take protected health information out of the office unless you were given specific authorization and or permission by the proper authority within your practice. If you are instructed to take protected health information out of the office, please make sure to protect it at all times and never leave it unattended unless securely and safely locked. Therefore, if in fact, let's say you are required to take protected health information out of the office, and let's just talk right now about paper. If you are asked to transport protected health information or it's part of your job duties, rule of thumb and a bit of advice: do not take that protected health information and store it within your vehicle where it could be seen, meaning the seats, the back seat, anything like that. What I suggest and offer it as advice is put it in your trunk, lock it in your trunk. Additionally, if there is a compartment within your trunk that you can pick up and hide, let's say where you may see the spare tire, or you might have a little compartment within there in the trunk that you can hide some stuff, if you will, some personal belongings, even better. What you don't want to do is leave it out in the open and you're driving with this protected health information and you decide for whatever reason that you have to stop. It might be for gas, but whatever it is, it's not a detour, meaning you're not going to go shopping with protected health information in the vehicle. The purpose of you having the protected health information is to get it to the next secure location. So you don't want to be detouring and going shopping and then your car getting broken into when you're at a shopping mall, let's say, and then it comes up in the investigation, well, I really wasn't supposed to be there, but I stopped off, I made a detour. You don't want to do that. Simply, you want to get from point A, being your practice, to point B, wherever it is that the location is needed, this protected health information, as safely as possible without doing any detours or anything of the like. In that instance, take the protected health information, put it in the trunk of your vehicle. If you can lock it within the trunk of your vehicle somewhere else or hide it, even better. But you don't want to make it so easily accessible that anyone who walks by might see it in your car. Never post, blog, write, disclose any information about an individual or their protected health information who is a patient, a former patient, a visitor, a workforce member, etc. from your practice on any social media forum, Facebook, Twitter, LinkedIn, whatever. Do not ever discuss any protected health information or disclose the identity of an individual, visitor, workforce member, present, former patient from your practice to any unauthorized persons. That means your spouse, sibling, parent, partner, friend, relative, etc. This often happens when you're at home behind closed doors. Hey, you know what happened today? Guess who came in today? Don't do that. Again, I know they're your spouse, I know they're your partner, they may be your boyfriend, your girlfriend, they may be your cousin, your aunt, your uncle, you might be at a holiday party or a family functioning or a birthday party. Whatever it is, do not make any disclosures about any person's protected health information who is a patient of your practice. And always remember to maintain the minimum necessary rule and do not disclose more protected health information than what is necessary to accomplish the task or request for the protected health information. If given permission from authorized workforce members within your practice to send protected health information via email, please be sure that the email is encrypted and only send the minimum necessary that is required for the disclosure. Never text protected health information to anyone over an unsecured text messaging system. Quite frankly, it's actually a good idea to simply not text protected health information at all. And business associates. Any privacy rule limitation on how a covered entity may use or disclose protected health information automatically extends to how a business associate may use or disclose the protected health information. Do not provide a business associate with more protected health information than is minimally necessary. And no protected health information should be disclosed to a business associate without first having a signed business associate agreement in place with your practice. Now let's look at amending protected health information. This happens quite often where a patient comes in, they see their record, and they say, you know what, I don't think that was right. I want to change something in my record. An individual has the right to request that a covered entity amend their own protected health information. Now, unless you have been given specifically designated permission by your employer with the authority to amend an individual's protected health information at this individual's request, you should never ever make any amendments whatsoever to anyone's protected health information. This includes your own if you are a patient of this practice. Any and all types of requests from individuals seeking to amend their protected health information which is held by your practice should immediately be directed to your practice's HIPAA privacy officer or the designated individual permitted to make such changes to an individual's protected health information. Let's talk about destroying physical protected health information. Prior to destruction, and by physical protected health information, I want to just reiterate and clarify that I'm talking about paper, where protected health information is printed up on paper. So prior to destruction, physical protected health information should be kept in a secure location in a locked container within your practice. Then thereafter, The protected health information should be rendered unreadable and indecipherable via a shredding process and not simply thrown out. The destruction process should be monitored and attested to via certification from a professional service company performing the destruction. Let's say, for instance, a shredding company gives you a certificate that the documents were shredded on a certain date. Additionally, I would ensure that this shredding process is such that it literally mangles and mashes and pulverizes the paper such that it's just not into strips which can be rejoined and constructed like a puzzle, put back together, and you can basically have this entire document reconstructed and you can see everything that was on there. You want it so that the shredding process essentially pulverizes and turns it almost into powder or dust. That is ensuring that anything that was destroyed via the shredding process can never ever in the future be reconstructed. Let's look at breaches. Now, unfortunately, breaches will happen within your practice. What you have to understand is that your practice is required by HIPAA to mitigate, that is, lessen to the extent practical, any harmful effect that is known to the practice of a use or disclosure of protected health information which is in violation of its own internal HIPAA policies and procedures or the requirements of HIPAA, again, by your practice or by its own business associate. So if there is a breach, your practice must have policies and procedures in place in order to start to lessen the damage that was done or caused by the breach that it is aware of. You also may be asked to help mitigate any harmful effect due to an impermissible use or disclosure. And do not, I repeat, do not under any circumstances attempt on your own to mitigate any harmful effect due to an impermissible use or disclosure, that is a breach, without first being given permission from your superiors on assisting with the mitigation of the breach, or the harmful effect of the breach, I should say. Sanctions. Pursuant to HIPAA, your employer is required to have and apply appropriate sanctions against workforce members who fail to comply with its own HIPAA privacy policies and procedures or the requirements of HIPAA. And your employer must document the sanctions that are applied, if any. And even after your employment with this practice, you still may not disclose any protected health information which you have handled, viewed, overheard, disclosed, etc. You must maintain the confidentiality of all the information you viewed, overheard, etc., and continue to protect it by not speaking about it, that is, disclosing it with anyone. I want you to keep in mind and always remember that non-compliance with HIPAA not only greatly affects the individuals whose protected health information was improperly used or disclosed, but the penalties for HIPAA non-compliance and our violations can range from $100 to $1.5 million against your practice per identical violation. So again, if you have 4 separate different violations that are not identical, each one can run a penalty of $100 to $1.5 million. And even more, the penalties for HIPAA non-compliance in some cases can result in fines, criminal fines, and the possibility of your incarceration. And when in doubt, refrain from disclosing protected health information until you have the opportunity to speak with your